Good morning and welcome to Concurrent Planning and Making Medical Decisions. If you haven't already downloaded the handouts, please click on the green link on your screen to download them so you can access them during today's session. Again, if you are participating in a group format or haven't registered via NCSW Learn for this webinar, please email us your name, your position, and your agency so that we have a record of you attending this session this morning. You'll see our registrar's information in red in the notes pod underneath our presenters' photos on the screen. So thank you for joining us today. We'll look at our agenda as we get started this morning. We have three main goals that we hope to achieve this morning. By the end of this webinar, we hope you will understand new legislation about concurrent planning and making medical decisions for children in care. We hope you'll have ideas for individualizing your case plans to meet the needs of each child. And finally, we hope you'll have information to help you educate judges and other court partners about these new requirements. Over the next 90 minutes, we'll have a brief orientation to this online meeting space, and I'll introduce our guest presenters. We'll then provide an overview of two recent major legislative changes, concurrent planning and making medical decisions for youth in care. We'll then look at case examples to show how these new requirements look in practice and offer tools to help you adjust to these new legislative changes. Finally, we'll be sure to leave time to answer some of your questions. We know we may not get to every single question this morning, but we will do our best. Many of you have already found the chat box this morning. This will be the primary way you can communicate with us throughout today's session. You can use this box to send in questions or comments throughout the morning. We'll try our best to answer all of your questions during the event. This box sometimes moves a bit fast, but don't worry, we have someone who's going to help us keep track of all of your questions. You'll see that there are two options in the bottom left corner of this box that lets you send a message either to everyone or just the host, meaning those of us here at UNC. Let's get started using this if you haven't already with an important question. Please use your chat box and tell us, what questions or goals do you have for this webinar? What do you personally hope to hear or learn? I'll wait just a moment for folks to type that in the chat pod. We see a lot of people typing. Folks are saying they hope we will understand concurrent planning better, a better understanding of recent changing regarding the roles of biological families. Lots of questions about those medical changes. Perfect. Understanding the legislative changes, consent for treatment. Great. So since this is just one 90-minute webinar and we have up to 500 people participating with us this morning, we know we will not likely be able to address every single goal, but again, we'll do our best. We will also be sure to share your questions and goals with others at the Division of Social Services, since we know there are lots of people who provide technical assistance, training, and support on this critical topic. So here is another way you can communicate with us this morning. You'll see in your top toolbar there is an icon. It looks like a little person with his hand raised. There are a lot of options in that drop-down box beside that icon. You can use this to let us know if we need to speak louder, if we need to slow down, or give us some applause throughout the morning. To practice this function, will you please use the raise hand icon to let us know if you're participating in our group this morning? We just want to see how many groups we have. We see lots of people with raised hands. Great. So again, if you're participating in a group and you have not registered via NCSW Learn, please send your name and contact information to our registrar, and we just put her email address in that chat pod again. So again, I'd like to welcome each of you to today's webinar. My name is Tanya Jacobs-Deese, and I am a clinical instructor with the Jordan Institute for Families at UNC Chapel Hill. We have technical help from our colleagues Philip Armfield and John McMahon and Matt Tarpley. Now let me introduce our guest. First, we have Ms. Erin Conner, who is a program consultant in the policy team at the Division of Social Services. Next, we have Judge Jay Corpening, a Chief District Court Judge for District 5, serving New Hanover and Pender counties. We're especially excited to have Judge Corpening with us this morning as he drove all the way from Wilmington to Chapel Hill to be here with us for this important topic. We also have Ms. Danielle McConaughey, Program Administrator for the Child Welfare Policy Team at the Division. And last but not least, we have Ms. Angie Stephenson, Child Welfare Attorney with the Attorney General's Office and Counsel to the North Carolina Division of Social Services. We will share their contact information at the end of this session, and you can also reference their bios in the handouts. With that said, I'm going to turn it over to Ms. Angie Stephenson, who's going to give us an overview of those legislative changes about concurrent planning.
Good morning. Let's see. It always takes me a minute to figure out how to advance the slide. Okay. Today we're going to talk about two distinct topics: concurrent planning and making medical decisions. So it's almost like two mini webinars. And the first one we're going to talk about is concurrent planning. There's been a big change effective October 1 around ceasing reunification efforts and concurrent planning. And so it's kind of a paradigm shift for social workers and for families. Beginning October 1, in most cases, you will no longer cease reunification efforts, and you'll do concurrent planning instead. The idea is that in most cases, reunification will remain a primary or secondary plan until the plan is achieved or parental rights are terminated. Now, some of you are probably asking, why did we cease ceasing efforts? So I want to start there. There were several things going on that kind of came together that made this sort of a logical choice. The first one that I just have to mention up front is that ceasing efforts was completely unnecessary. There was nothing that required North Carolina to have that juncture in the case. So it was definitely something that was done in North Carolina traditionally. It was in the statute, but it wasn't necessary. It was also rated as an area needing improvement by the federal government when they came in to do the Child and Family Services Review in 2007 and then again in 2015. There are expectations at the federal level that social workers continue to maintain contact with parents until permanency is achieved. It created an appealable issue. It created an issue that could be preserved and then appealed later, possibly allowing a case to be overturned. It also was probably in a lot of counties was the third most time-consuming hearing on the court docket. So it was taking a lot of time and then also creating a possibility for an appeal. It created a situation where children were more likely to lose touch with their siblings. There are also some counties where social workers were not even returning calls from parents after the cease reunification decision. So when a case would get finally to termination of parental rights, and sometimes that could be several months after the goal was changed or after efforts were ceased, the parents could come in and list out a bunch of things that they had done, and there was no way to know whether or not they had done them. So there was no accountability for parents at the termination of parental rights hearing. And when parents really did make progress, there was no way to verify it. So there were a lot of reasons why ceasing efforts was causing some problems. So we started looking for some alternatives. And the legislature in the 2015 session created a kind of a different paradigm, which instead of ceasing reunification in most cases, you're going to continue to provide reunification services. There are some exceptions, though. So you're still going to be able to cease reunification efforts in a couple different places. One of them is at disposition. And this has always been there, but it's probably been underutilized. In certain circumstances, the court is able to make findings at the initial disposition hearing, and reunification efforts can cease immediately at that time. And we're going to have a polling question about this.
Thank you, Angie. So you'll see that I'm dragging a poll onto your screen. Before we talk more about ceasing reunification, we'd like for you guys to answer the poll. So the question is true or false. If the court has found that a parent committed chronic physical or emotional abuse against a child, reunification efforts shall not be required. So go ahead and click on the answer. So it looks like we have a 50-50 spread for true or false so far. We'll give a couple more folks the opportunity to answer. Now we see more folks for false. All right. Thank you for participating in that poll. So now I'll turn it back over to Angie for her to give us the answer to that question.
Okay, so the answer to that is true. Actually, I went too far. Okay, so that answer to that is true, and we're going to talk in more specifics about that on the next slide. But there are circumstances, along with the one that was just mentioned, where the court can cease reunification efforts and must actually cease reunification, or it's actually phrased a little differently than that. Reunification efforts are not required when certain findings are made. So let's talk a little bit about that. But first I want to talk about the other circumstances where reunification efforts can cease. So the next one, so the first one is at initial disposition. The second one is when the court finds that reunification efforts clearly would be unsuccessful or would be inconsistent with the juvenile's health or safety. And this would be a finding that would be made at a permanency planning hearing only. So that's the next time that that can happen. If this happens, if efforts are ceased at this juncture, then that hearing and those findings could be preserved for a later appeal, just the way they were before the legislature changed this statute. And then in every other circumstance, reunification is going to continue either as a primary or secondary plan. And we'll talk more about what that means as we go along today. So the first area, oh, actually, I'm going to turn it over to Tanya for just a second.
Thank you, Angie. I have a quick question for Judge Corpening. So here, this section says that reunification efforts shall cease rather than may cease. Can you talk a bit about that difference?
Sure. This is one of the more concerning areas of the new statute because shall is a clear mandate. The Court of Appeals has clearly interpreted the meaning of the word shall for judges. And so making these particular findings triggers that mandatory ceasing of efforts. There are two particular areas that I've been concerned about and am hopeful that the General Assembly will take a look at, and those are where there has been a prior termination of parental rights or the chronic or toxic exposure to substances, which in our community and others around the state are our addicted babies, our newborns that are born addicted. You know, we've had lots of success with parents even after they've lost children to termination of parental rights proceedings. They figured it out. They're working their plan, and I struggle with the notion of ceasing those efforts immediately at disposition and not working with that family. We've had some incredible successes with parents turning it around. So I think that if you've got a situation where you believe a parent is going to make the efforts, is going to work the plan, then encourage the court not to make those findings. You still need to have enough findings to support the adjudication. But in lots of those cases, you're going to have stipulations and not contested trials because they are working. They do recognize the problem, and so not making those findings then would not trigger the use of that word shall in ceasing efforts at such an early stage.
Thank you, Judge Corpening. So can you give us just a little bit of an idea of what judges may be looking for to be able to cease efforts?
So I think you look at the reasons for removal. For example, you've got a dual diagnosis parent with significant mental health issues, substance abuse issues, and in looking at whether to cease efforts or not, we look at whether they're in compliance with their treatment, either their mental health or substance abuse treatment or both, whether they're visiting with their children regularly or not. And I think that oftentimes in cases where we are ceasing efforts, it's really fairly clear. They're non-compliant with treatment, they're not visiting their children, they're not in contact with the social worker, they're not returning calls from the guardian ad litem, and I think in those cases it's going to be pretty clear.
Thank you, Judge Corpening. I'm going to turn it back over to Angie to talk about the findings needed at that initial disposition.
And this will dovetail nicely with what Judge Corpening was just talking about. The findings needed at the initial disposition, there's a whole long list of circumstances where the court can make findings that then will trigger that language about shall require that reunification efforts not be required. The first is a category that used to be defined in the definition section as aggravated circumstances. And that would include sexual abuse, chronic physical or emotional abuse. Emotional abuse was added in, that didn't used to be there. Torture, abandonment, chronic toxic exposure to substances that causes the juvenile to be addicted. That's a new one as well. And then another act that increases the enormity or added injurious consequences. So those are your aggravated circumstances. Then you also can look at whether if there's been a prior termination of parental rights with that parent, and then a prior court has determined either murder or manslaughter of another child of the parent, attempted murder or manslaughter of a child of another parent, felony assault or bodily injury, sexual abuse, or they're on the sex offender registry. So those are all situations where the court can make findings that would require efforts to cease at the initial disposition. And like I said, many of these were already in the statute, but were probably underutilized. Okay, now I just want to talk about what the permanent plans are. And these permanent plans existed before October 1, 2015, but they weren't laid out quite as succinctly in the statute. Now they're found at 7B 906.2. They're reunification, and that would mean reunification with both parents. Both parents should be considered for reunification right from the beginning. We will maybe talk about that a little bit more as we go along. Adoption, guardianship, custody with the court-approved caretaker, could be a relative, APLA, which is another permanent plan living arrangement or another planned permanent living arrangement. I get my P's mixed up sometimes, but it is it's only available for older youth, and we'll talk about that in a little bit as well. And then reinstatement of parental rights, which would not be a permanent plan until after parental rights were terminated for some time, but we list it here just because it is in the statute now as a permanent plan. Okay, I want to talk a little bit about what is happening when we are doing concurrent planning. And the reason why this slide is so important is that I think when people first were hearing about concurrent planning as being used instead of ceasing reunification efforts, there was some fear that went around that if you were doing, as a social worker, if you're doing 100 units of work toward reunification, how can it not be now 200 units of work if you're adding in another concurrent plan? And the idea behind concurrent planning is not that you're going to double your workload, but that you're going to work smartly so that you have a proper backup plan, if you want to think about it that way. And so, it needs to be really individualized based on the case. So in one case, you may have a situation where you're working 95% toward reunification and only 5% toward adoption. And that's a case where things are going really well toward reunification, but you're still, doing some things toward adoption. You're open to that, and you're having that, you're doing the things that you can to make that plan available if you reach the circumstance where reunification doesn't work out. Another case, you may have a situation where you're working 80% adoption, but 20% reunification. So most of your work is going to be going toward the adoption, but you're still doing some backup kinds of things with reunification. I'm going to turn it over to Tanya.
Thank you, Angie. So, question for our panelists: what might it look like to say reunification is our primary plan and adoption is our secondary one, or that adoption is the primary plan and reunification is the secondary one? How do you do both of those at the same time?
So I'll bite on that one. Now that I've unmuted my mic, so I think that the key is that as long as reunification is either a primary or a secondary plan, if it's one of the concurrent plans, then you still got to work with that family towards reunification with both parents until efforts are ceased or permanence has been achieved. And so that means, for example, that visitation with the parents continue as if reunification is a plan, so visitation continues. Providing mental health treatment or making mental health treatment or substance abuse treatment available is still required. You don't, as long as reunification is one of the plans, I think we cannot step away from those services that enable those parents to work towards that plan, even if it's a secondary plan and not the primary plan.
Thank you, Judge Corpening, because we certainly know we want to give parents opportunity to visit with their child and to work towards reunification. So, Erin, can you tell us or give us a little bit of insight of how you might individualize concurrent planning efforts with children?
Sure. Excuse me. I would just like to emphasize that it is really important that you individualize your efforts, and no matter how your concurrent planning shakes out, whether you're working 95% reunification, 5% adoption, or 80% adoption, 20% reunification, it's all going to be really dependent on the child's needs and the family's needs, and what are your overall goals for the family, and what would you like to see in terms of outcomes. So being flexible is really important. One of the ways, I think Judge Corpening already mentioned a couple of examples about how that can really happen and what kinds of things that you might need to still provide to the parents even if you're working more towards adoption, or the kinds of things you could be doing if your adoption is your secondary plan, in terms of trying to get an idea of fit in terms of a family that would be appropriate for adoption of this child, or whether if you're working more towards adoption, making sure that visitation is still happening, working with the parents towards meeting their goals. If reunification is still your secondary plan and you're kind of doing the 20% towards that, and really how can the parents help facilitate working towards the primary plan? How can they continue to support their children and working towards the permanency? I don't know if that helps. Does that help?
It does. Thank you, Erin. So a couple of quick questions that I do want to throw out there. So someone asked, what are the guidelines if there are percentages? So what does 20% efforts towards reunification look like? Does anyone have guidance on that?
I can talk about that a little bit. I think the whole idea is that it's going to look different from case to case, and that knowing your families and knowing the services in your community and knowing what resources the families have, you're going to be able to determine that. And the other thing to point out is that the court is probably going to have some ideas about what that means, and the statute clearly says that the court can make findings about what that will mean in a specific case. So I don't mean to punt it, except that we don't want any automatic formulas. We want these to be really individualized.
I agree with that. I think that's very, very important. And that's, I guess, in some ways that's trying to put. So I was talking and no one could hear me. I think it is important to be individualized, and to some extent what we're doing is putting a statistical likelihood on these plans, I guess. But I think that the more important thing is to have a plan that's more likely than not to succeed as being the primary plan, and then the other plan being a secondary plan. But as long as the word reunification is there, then we still have to make efforts to make that happen. So I think that we need to be careful not to get lost in that. I think the other thing that we need to be careful about in this concurrent planning is if adoption is a secondary plan, regardless of whether we believe it's a 30% or a 5% or 10%, we need to be careful not to raise expectations about that being the final plan. Had a case just last week where some foster parents' hearts were broken. It was not a case where there was significant likelihood of adoption. Adoption was the secondary plan, but all they heard was the word adoption, and they believed that they were going to get these children. And the plan changed, and adoption was not part of the plan, and they were crushed. So we need to be careful about that.
Thank you, Judge Corpening. I'll turn it back over to Angie, who's going to talk with us more about permanent plans, or to Erin.
I just was going to mention real quick, and we'll go over this in a little bit more detail later on, the updated out-of-home family services agreement should hopefully provide the opportunity to really look at that individualization for your primary and your secondary plans in terms of addressing what are the overall goals for this family, what are the barriers to achieving either the primary or the secondary plan, and you have space to input that information, both what are your goals and barriers for each plan.
Okay. Thank you. I'll turn it back over to Angie.
Okay, sorry. All right, so I'm going to go through this fairly quickly, but again, if there are questions, please put them in the chat box, and we'll either get to them today or in the follow-up document. So the required findings when you're looking at permanency planning orders are that the court has to address the reasonableness of efforts toward permanency plans, and as I said earlier, the court may order specific efforts that the court expects to happen from DSS, and I think that would be actually very helpful for the social workers when they come in to the next hearing to know what was expected of them. It also needs to address the parent's progress within a reasonable amount of time, parents' cooperation and participation with the plan, parents' availability to the court, the DSS, and the child's GAL. It needs to address whether the parent is or is not acting in a manner consistent with the child's health and safety. And then if the child is over 14, then the court will also be addressing findings that are in the new 7B 912, which we'll discuss in just a little bit. Okay, I already saw the question in the chat box. What if reunification efforts already had ceased before October 1, 2015? And they have to, you don't get a pass. You have to, again, the court is going to have to keep, at every permanency planning hearing, look at the new issues that come up. So the court will have to look at the situation based on the findings that are in the statute now at the next permanency planning hearing.
And I think it's important to remember that that's a must. So eventually within our cycle, every single case will have a concurrent plan. There was a question in the chat box about if both parents had relinquished, is it required? Well, no. If both have relinquished, then no, parents don't have to be part of the concurrent plan because that's moving towards permanence and they don't have to be involved. But otherwise, every plan has to be updated.
And Judge Corpening, while I have you on the mic, can you talk a bit about what you would look for to make a finding of reasonable efforts?
Sure, and I'll give a shout out to my folks in New Hanover County as part of my answer, because in the court reports that I get in my abuse, neglect, dependency hearings, they chart everything that has been done. They chart visits, they chart treatment visits, they chart anything that the social worker has done in an effort to work on that plan. They also document what the parent has done or not done in response to that. And so that's what I'm looking for is I'm aware of what the grounds for removal were, and so we've got a plan. What's happening in support of that plan, and my folks do a great job with their reports in documenting that. I would encourage everyone to use the model court report. It's been updated, and hopefully I don't have that, but hopefully you've got access to it, and if you don't, give us a shout and we'll try to get you to how you can find it. But that's a great resource in documenting what you've done, and that's so incredibly important because we know what happens if a judge says you haven't made reasonable efforts in a case. It cuts off that federal funding stream, and so we want to make sure that we're documenting that for every hearing.
All right, thank you, Judge Corpening. So you can access that model court report at the beginning of our handouts under resources. There are a couple of links there. I see a couple of questions that we want to get to. So someone mentions there has to be a limit to this process. How long does the team have to work towards reunification? Anybody want to take a stab at it?
So I think we're still governed by our process of working towards a permanent plan within a year. And if we haven't by the time we get to permanence planning hearing, then we need to be looking at what realistically can happen to achieve permanence. So I think that's what we do. We continue to do that. And if the parents aren't responding, then we need to document that and move forward. I'll tell you that this is going to be, in practice, one of the most difficult parts of this, because if we're still have reunification as a secondary plan, but adoption as a primary plan, moving towards termination of parental rights, it'll be interesting to see how that plays out. But I think that this doesn't necessarily change anything about what we do in terms of timelines. Angie, you may have an opinion about that.
No, I think that's right. I mean, the idea is that rather than limiting, like cutting it completely off during, at a certain time, what you're doing is you're being completely transparent about the process, and you're limiting it. You're still doing a minimal amount of services toward reunification, even if adoption or some other plan is the permanent plan. I think that I've heard, it's one of the things I've heard the most from social workers is that it feels inconsistent to be working adoption and reunification at the same time. So it would be great to hear from some of you about what you're doing. If the plan is reunification, but you've got a secondary plan of adoption, what are the things that you're doing toward adoption, and vice versa as well. If the plan is adoption and you're still working on reunification, how are you pulling that off? Because I think that really is what you're getting at with the question about having a time limit. Now I'm going to turn this over to Erin to talk about the forms.
So I want to get to two quick questions first. So Holly had a question: if the secondary plan is reunification, is the state standard of monthly face-to-face contacts with the parent still applicable? Are the required state assessments still required?
So we've got some technical issues that we're working on, but I'll go ahead and start on that. I think the answer is yes. I think that we do have to continue the monthly contact and everything else. And I think we've got sound down at the other end of the room now.
Right. Can you guys hear me now? Okay, great. I'm a good Verizon commercial. Yes, and I want the field to recognize that as long as reunification is on the table, we are making all the efforts and the contacts that we need. That's very important. Typically things fall off when we think the plan is changing or we put more efforts towards that other plan. But as long as you have reunification, we still need to engage these parents. Those are things at the federal level. They're looking at the state in terms of our engagement and contacts with the parents to achieve that plan, even if it's not your primary plan.
Thank you. So I know there's lots of questions out there, and what I will say is that we will create a follow-up document with answers to frequently asked questions after this webinar, so be on the lookout for that. I do have one more question, and then I will really turn it back over to Erin to talk about the updated forms. So Jackson County looks like they had a couple of questions about ICWA and how this would relate to ICWA. So does anyone have guidance on that? Or it may be something that we could put in the follow-up document. I think we'll Jackson County, if you could email your question, because I believe you had a couple, to me. I'm typing it in the chat pod right now. Email those questions about ICWA to me, and we'll make sure to address that in that follow-up document. In the essence of time, we'll go ahead and move it over to Erin, because we want to talk about these updated forms that you need to know about.
Sure. Can everybody hear me? Okay. Good. You can? Okay. Awesome. So there's, on this slide is a list of some forms that have been updated recently in response to legislative changes both at the federal and state level last year. We're going to go into more detail about the Out-of-Home Family Services Agreement in the next few slides, but I wanted to mention the Model Court Report for Permanency Planning Hearings, which does provide a space to talk about agencies' efforts towards both plans, primary and secondary, as well as there were updates to add conversation and discussion around the child's opportunities to engage in age or developmentally appropriate activities, as well as to provide more information about the appropriateness of APLA as a permanency plan in terms of the agency's efforts on an ongoing basis, whether unsuccessful or not, to return the child home or place the child with a fit and willing relative or with a legal guardian or an adoptive parent. So that's just something to look out for. I think it was mentioned that there was a link to that in the handouts, and on my handouts page where the resources section is, on that first page, I don't see a link to the Model Court Report. So I'm not sure why that's not there, but it's on the DSS forms page. Also, the Plan for Emancipation from Foster Care Custody was amended to include changes in terms of the documents that youth need to be provided with when they age out of foster care, including a driver's license or other state-issued identification, medical and educational records, etc. That stuff is listed in the Emancipation Plan, and also I think is discussed in the placement policy. Furthermore, in the resources section of your handouts on that first page, there is a link to the Understanding Foster Care Handbook for Youth, which has provided similar updates in terms of changes to the law for youth aging out of care and their access to certain documents and other areas, their rights and things of that nature. So there's a link to that for you. Now we'll go on and we'll talk about the out-of-home family services agreement. So the highlighted sections that you see on this slide are what has changed on this particular page. Now, we didn't put images of all the pages in this presentation, but we do have the pages where the changes have occurred in the document. I do understand that there may be some issues with the way that this document is formatted in PDF in terms of its interactivity and ability to type stuff in certain sections and that you have enough space. So we're going to look at amending some of the those formatting issues in the very near future. So the important things on this page, I'll just point out, we added reinstatement of parental rights as a permanency option, and we've split the primary and secondary plan so that you can, rather than just having a space that says this is the secondary plan or that there is a secondary plan or concurrent plan, you have an option to check what that is. So this is where I was talking, but previously this form, the way this form was divided is that you had a section to talk about the objectives and the activities, and then the barriers was split. If reunification was your primary plan, you filled out one page. If it was not your primary plan, you filled out a different page. What we have changed about this is so that you have this page where you can fill out what are the overall objectives, what are the activities, what are the needs. You can talk about strengths and needs of the family and the children, behaviors of concern, and your overall objectives, activities, who's responsible, and your target dates, and that you can do this for both your primary, just that these overall goals and activities would apply for both plans essentially. And now what we have is two pages, one where you would fill all of these pages out no matter what your primary and secondary plans are. So you would have the progress towards meeting your identified needs, and this is where you would include all of the progress. And again, the needs are going to apply no matter what your plan is. We may split that off later, but and then you have a section where you can, this is a new section, where you can add the barriers to accomplishment of the primary permanency plan, and this is where we separated it out, because remember there used to be just a section you would fill out for reunification if it was your primary plan, and then not if it was not. But you can fill this page out for your primary plan, no matter what that primary plan is, and then you can again talk about your progress towards overcoming these barriers for your primary permanency plan, and then again the same pages for your secondary permanency plan, so you can address both on the same document. Does that make sense? Okay. And again, you can document your progress towards overcoming your barriers for your secondary permanency plan. This page is new. We're providing specific information about services to children and youth, including what's their face-to-face contact between the child and the agency. What are their opportunities to engage face-to-face with their worker? What's the plan or their opportunities to visit with their parents and siblings? What does that look like? What are the opportunities they've been afforded to participate in their own case planning, as well as their opportunities to participate in age or developmentally appropriate activities, and other things like what are their education and health services, what's being provided in terms of that to support their education and their health, and other referrals to community agencies. There is also a box to check for a certification that they have received the Understanding Foster Care Handbook, more specifically the page in there that discusses their rights. So you can check that box that they have received that handbook and that they have signed, that they have received information about their rights. There's also a page in that handbook, the page that they can sign, that you can copy for your case records. And then again, anything else that's related to the services to the children. Under the services to placement provider, we have added information about the opportunities that the placement provider is affording the child to participate in age or developmentally appropriate activities. I don't want to go into too much detail about that. That's really speaking to the reasonable and prudent parent standard, which we've already talked about in previous mediums and webinars. So we'll move on from there. I just want to point that out. And I think that's it for the out-of-home family services agreement. If there's any questions about that, type them into the chat box.
So there was a question about the out-of-home service agreement being shared with private agencies, and it's my understanding that the out-of-home family services agreement should absolutely be shared with private agencies providing services to the child, and that the staff of those private agencies should be invited to participate in child and family team meetings. Anything you want to say about that? Just a friendly reminder to everyone. We do have a couple of questions I do want to get to. So someone asked, is custody to a non-removal parent a permanent plan in this statute?
We'll go ahead and take that. That is still in the out-of-home services agreement, and I believe that's kind of a holdover to the form, what was in the form before the statute changed to define reunification as applying to either parent. So you probably will not be using that checkbox. You're going to instead want to probably make it clear that you're working reunification with both parents as long as they have parental rights. And I saw another question earlier about if parental rights had been terminated. If parental rights had been terminated, you do not work reunification unless you're looking at that specific situation where it's reinstatement of parental rights.
Okay, I'm going to chime in real quick because I see a question that I would like to answer, if that's okay. There's a question in the chat box about the handbook itself. In the handbook, it does say that the target age of youth to give the handbook to is 12 to 17. It's not, you don't necessarily need to give it to all children. That handbook was written with the target age group in mind, but if there are other ways that you can communicate with children younger than 12 in terms of what their rights are, you know, communicating with them on an age-appropriate level or involving them in case planning, absolutely do that, but you don't necessarily have to furnish them with the handbook because of the audience that it was written for.
Okay, and then I just want to talk a little bit about juveniles 14 and over because this is affected by permanency planning, although we did speak to it in the earlier webinar about normalcy. The new General Statute 7B 912 requires specific findings about services provided for transition to adulthood, use of the reasonable prudent parent standard, and age or developmentally appropriate activities. Then the other thing to remember is that at least 90 days before the youth turns 18, the court must ensure that the juvenile has access to birth certificate, social security card, health insurance, driver's license, or other ID, educational and medical records. I'd like to ask Danielle, though, to talk a little bit about what the emancipation plan is and how it relates.
Thank you, Angie. And Erin referenced this plan earlier in terms of the updates, and this is a plan that we need to make sure that we are providing and planning with involving our young people 90 days before they age out of care. This is part of their plan, and if you think about APLA, there's a slide regarding APLA. Technically, they are aging out of care, even though that is a permanency plan. Those young people do not have the type of permanence that we would desire, so it's the plan of last resort on some sorts. And so we need to make sure we are doing that emancipation planning, even if they're not in APLA or if they're just going to be exiting and going out in the communities by themselves. So they need to have these transition documents, and we should be involving them in the planning and letting them know why they need this information and how it's going to be used as they exit. Because remember, these young people typically don't have these documents, and we're floating these documents around through caretakers, and they're not being responsible. And so we need to involve them on that, because a lot of times once they hit 18 or they exit care, they don't know where to get anything or how to access services or employment and things like that. And in terms of concurrent planning, the tie-in is essentially to APLA more so, why this is more important, I think.
Thank you, Danielle. Quick question while I have you on the mic. Someone asked a question about the age range for kids receiving the foster care handbook. Can you tell us what that age, remind us of what that age range is?
I think Erin just referenced that in terms of the target audience for 12 to 17-year-olds. However, if there's information in there that can be used for young people out of that age range, you certainly can use that information and tailor it to their needs.
Thank you. I just wanted to mention that again. I know a couple of people missed that age target. Thank you.
Okay, and then that was a nice segue into talking about another planned permanent living arrangement. There it is. I've got my P's in order now. This has been a goal in policy, a permanent plan in policy for some time, but now it is actually in statute as of October 1, also in 7B 912. It sets some stricter limits, and that is actually at the direction of the federal government. They want us to limit APLA to only youth that are really unlikely to have a different permanent plan before they reach age 18. So it's only available for youth age 16 or 17. The court has to make a finding that the DSS has made diligent efforts to place the youth with a parent, relative, guardian, or adoptive family, and also that there are compelling reasons that adoption or guardianship is not in their best interest. And finally, the court has to say that APLA is the best permanent plan for the youth. So it's really a narrowly available permanent plan, but for some youth it is really the best permanent plan, and it's certainly geared toward making sure that the youth ages out with skills that they'll need for adulthood.
Mm-hmm.
The final thing to mention about that is that for youth that have APLA as a permanent plan, they are going to need to come to court because the judge has to question the juvenile. I believe that there probably could be some flexibility around being creative about possibly questioning through Skype or over the phone. I mean, some of that might be available, but the judge does have to actively question the juvenile. So in most cases, you're going to want to have them come to court.
So I see there's a comment that we have a hard time getting APLA ordered in some of our districts. Judge Corpening, could you weigh in on some things that you would look for before issuing such order?
So first I would say it's supposed to be hard to get APLA ordered. It's a last resort, and I think that the new statute gives us some clearer direction about when it can be ordered, much clearer than before. With those categories, we know that it's got to be 16 or 17. We're going to know because over the duration of the case, there have been lots of efforts to try to place this particular juvenile somewhere, and we've not had success. And so APLA really is the last-ditch plan before the child turns 18. So I think it really is supposed to be a case of last resort, and it's supposed to be hard to get a judge to say APLA.
Thank you, Judge Corpening. So again, I know we have a lot of questions out there. We will answer as many as we possibly can, and we'll also have some questions and answers that are frequently asked in that follow-up document. I'll throw it out to our presenters. If there's any burning questions that you see that you really want to get to, please feel free to go ahead and jump on your mic. Otherwise, we do want to move towards making medical decisions so that you guys get all the information that you need about our other major legislative change. All right, we'll move forward. So I'll turn it back over to Angie, and she'll give us an overview about how we should make our medical decisions.
Okay, thank you. And we're switching gears now. The two topics really aren't related, other than the fact that they both were into the legislation that went into effect in October 1, 2015. So let me talk a little bit about the background for this new legislation. And the first thing I want to say, because I know that counties are struggling with this, but it really didn't change a ton. The statute itself didn't change a ton. It was better organized, and it was clarified, and there were some more details. But the essence of what's in the statute now was in the statute before. There are just some things that changed to kind of create a different scenario. And a big one is that the AOC form, which is the non-secure custody order that is signed at the original time, when the court orders that the child come into non-secure custody, that form used to have a checkbox at the bottom that just gave DSS carte blanche authority to make medical decisions. That checkbox is no longer there. AOC has taken it off, and I'll explain a little bit of the background of that. But that's what really changed. And so that instead had required DSS to look at what was in the statute. And there's now a new statute that it's 7B 505.1 that really clearly delineates when DSS has the authority to consent to medical treatment and what happens when in other circumstances. So the other pieces that were, so the different things that kind of came together to create a situation where the legislature needed to address this were, one, that the federal government was really encouraging states to provide more parental involvement with medical decisions, particularly around psychotropic medication decisions, because youth in foster care are typically given psychotropic medications at a much greater rate than the general population. So that was happening. There also was some there's a lot of movement around from Fostering Health NC as they're trying to establish medical homes for foster youth, and they were trying to clarify the medical consent issues. And then finally, the one that I referred to a little bit earlier with the AOC form, that happened after the school of government came out with a bulletin that said that checkbox may actually be unconstitutional. And so it was really important that this issue be addressed. Under the new legislation, I mean, this was actually here before, but it's really clear now that DSS, prior to a hearing, DSS can only consent to routine or emergency care and sometimes the child medical evaluation. After a hearing, you'll either have more parental involvement or DSS will be given authority by the court. And so that first hearing is a 7-day hearing. So we're looking at routine or emergency prior to the 7-day hearing, and then after the 7-day hearing there are some different options.
So before Angie goes further about our medical consent, we have another polling question for you, and I'm dragging that so you can see it. So the new legislation requires, you have 4 different options there: a hearing every time a child needs treatment that is not routine or emergency, the parent must sign the medical provider's consent to treatment, or court order or parent's authorization for the county to consent to treatment that is not routine or emergency, or the county can consent to everything after the first hearing. So go ahead and vote which answer you believe is correct. All right, looks like the overwhelming majority says number 3. So Angie, can you give us your feedback on this one?
You guys got it. It's number 3. That's the right answer. So there will be 2 options. The court can either order the county to have authority to consent to treatment around a specific issue, or the parent will give authorization. And you'll see in your handouts that there's a form, and you'll have a chance to go over that more a little bit later. But there is a new form that should be coming out. It's not official yet on the website, but you have a draft version of it in your materials that can be used for the parent to give that authority. Okay, so the way that this works, I already mentioned DSS can consent to care that's routine or emergency. The other circumstances that are listed in the statute are testing and evaluation in exigent circumstances. And that, we're not exactly sure the parameters of what that is, but I can think of, I've talked to several medical providers about this issue, and one thing that comes up that I think would probably fit well into this category is a situation where a child was brought to the emergency room. Say that the child was brought to the emergency room with multiple fractures and broken bones. The emergency is treating those injuries, but you really, the medical providers really need to do some additional testing, like x-rays and that kind of thing, that go beyond the emergency. Well, that might fit under testing and evaluation in exigent circumstances. And I think that's probably going to be a narrow category, but there may be some other examples similar to that where it fits in, and probably some in the mental health area too. But we'll probably just recognize them when we see them. And then the final one is the child medical evaluation in certain circumstances. Now remember, I said that only routine and emergency can be consented without a court order, so without a hearing. So that between the non-secure custody moment when the child comes into care and that 7-day hearing, you're typically going to only do, or DSS is only going to be able to consent to routine or emergency. There are some compelling circumstances that require a CME to be completed before that 7-day hearing. And when those exist, then the court can order that at the initial non-secure. But the court is going to have to find that the director has a compelling interest in having that child medical evaluation completed prior to the 7-day hearing.
And Angie, quick question. Can you give us a little bit about what a compelling interest might be? Or should we put that in a follow-up document?
It's hard to think in the abstract, but I probably would, from talking to medical providers, it's probably not going to happen very often. It would be maybe in circumstances where there would still be a reason where the child would, if there was physical evidence that needed to be collected, that would probably be the big one. Can you think of any others, Judge Corpening?
No, because typically that's going to have happened pre-petition. But if allegations are, for example, sexual abuse, and there hasn't already been a CME, then that's the kind of exigent circumstance that would lead to getting that done even before the 7-day hearing.
And even if you don't get that finding from the court, you can go ahead and schedule the CME to occur on the 8th day after that, or whatever, right immediately following the 7-day hearing. So we really are, I don't think there are, from talking to providers, there are very many CMEs that are occurring before 7 days anyway. And in those circumstances where they need to happen, we have this provision in the statute to allow it. So just remember to ask the court for that if you need it.
So there's a lot of questions about what routine is, and we expected that. So we have another polling question for you guys, for you to answer of what you believe routine is. So just click on the bullet on your screen and which one you think is correct. So we say most people are saying immunizations, although we have a lot of people who are saying all of the above. So I'll turn it back over to Angie to talk about routine.
And the answer here is number 2, immunizations in most circumstances. Immunizations will be considered routine as long as the parent doesn't have a bona fide religious objection. The other two, which I'm trying to remember what they were. I'm sorry. I lost it. Thanks. The other two may be routine in foster care settings, but what we're looking at here is an objective view of what's routine, so it would be routine for any child. Because what we're looking at is, we're giving, prior to the hearing, if you think about it, if you're a parent and you have some allegations against you, but no court has made a single finding about whether they're true or not, you really have all your parental rights. So we're talking about taking parental rights over and making decisions instead of parents making them. So we have to look at an objective view of routine. And the new prescription for Ritalin and the comprehensive mental health assessment both would be non-routine when you look at it objectively. But that only means that you wait until after the hearing. If you know that this child needs a new prescription for Ritalin or a comprehensive mental health assessment and the parents aren't willing to authorize you to consent for it, then you definitely want to be asking the judge about that at the 7-day hearing. Okay. So, some other things that the court must do, or the DSS must do under 7B505.1, and then after the adjudication and dispositional hearing, then it's also referenced in 7B903.1E, but it refers back to 7B505.1. So basically all your medical decision information is in that statute. DSS must make reasonable efforts to notify the parents about medical issues, give frequent status reports, make records available that DSS has. It doesn't impose a new duty on DSS to collect additional records, but makes those records available, except that the results of the CME will be only shared according to the discovery statute, which is 7B700. And then DSS must share information with providers. Providers are authorized under the new statute to share information with DSS and the parent, unless the court orders otherwise or there's a federal law that prevents it. I want to also point out that there is a statute in Chapter 90 of the General Statutes. It's 90-21.5 that allows minors to consent to certain services themselves. These are medical health services for the prevention, diagnosis, and treatment of venereal disease and other diseases reportable under GS 130A-135, pregnancy, abuse of controlled substances or alcohol, and emotional disturbance. So just be aware of that. A minor can consent to their own treatment for those things.
So Angie, quick question. Just wondering how, or can you give us a little bit of background or context about how this law about medical consent came about, or why it came about?
You know what? I did that ahead of time in the beginning. It was those three things that were kind of converging at the same time. There was the fostering health and C, working on the medical home issue, and the increase in the federal government wanting to involve parents more with psychotropic medication, and then the final one was the learning that probably the checkbox on our AOCJ 150 or non-secure custody order was likely to be unconstitutional, and it was removed from that form. But yeah, it's good to be reminded, because I think that it was a little bit of a mystery to a lot of people about why we were looking at this so carefully.
So I know there's been a lot of questions about the DSS 1812, and we're going to talk about that in just a minute. I will mention that the handouts that were in the link at the beginning of the slides today were updated from the ones that you received via email. The reason for that is the DSS 1812 changed. Literally, we received the new form on Monday, so that's why it's a little bit different. So at the end of our session today, I'll go back to that first slide so you can download that handout, and then we'll also include the new version of the form in the DSS 1812. I'll turn it over to Erin now to talk about the form, and just also alert you that there's a question of course, this form isn't on the website yet, so does that mean can we go ahead and use it, or should we wait for a little bit?
I'm hoping that this will be on the website very soon, and I'm going to let Angie speak to whether, I don't know that there would be a reason for them not to use, at this point. So, if you, I know that this one you've got it as watermark draft, but if you want to, copy the language into your own format, that's perfectly fine. So let's go ahead and take a look. So this is it's a pretty short form. It's about, what, 2 pages? The first box on the first page is where you would enter, it's pretty basic, the child's name, their date of birth, their medical home provider if they have one, the phone number for their medical home provider, and then boxes for the name and contact information of the practice if there's other providers involved, or dental or mental health, or a certain specialist that maybe the medical home is referring to, or who is administering the treatment if the medical home provider is not the one who is recommending or administering a specific treatment. Let me jump back a little bit and talk about the purpose of this form. We've kind of done that a little bit, but just to say that the purpose of this authorization for treatment and medication is to make sure that children in legal custody of county child welfare agencies receive the care and treatment that is necessary, and that county child welfare agencies are engaging parents in the care and treatment of their children. So this form should be used to obtain the parental authorization for the agency to consent for the treatment for which a county child welfare agency director or director's representative does not have the authority to consent under that statute 7B505.1. The next box talks about care, treatment, and parental consent, and there's going to be an instructional document that is a companion to this form that kind of goes into detail about all these sections. That's actually what I'm looking at now as I'm describing this form to you all. So you'll see those bullet points that enumerate the same things in the statute that Angie talked about previously in terms of routine medical or dental care, treatment, emergency, or testing and evaluation in exigent circumstances being things that the county can arrange for, provide, or consent to. Below that is where you would fill out information. So it says, I hereby authorize, and then there's a blank. So you would type in the name of your county. Child welfare agency to consent to the following treatment of the child identified above and include a description. So you'll have an opportunity to enter information, whether it's for prescription for psychotropic medications, participation in a clinical trial, a child medical evaluation that is not otherwise authorized, and there's a few more circumstances. I couldn't fit the whole first page on this one slide, so we'll talk about those in a moment. But I do want to point out that if you're obtaining a child medical evaluation, even if you get this form signed, you still need to have the 5143 consent or authorization for a child medical or child family evaluation completed as well. I'm going to go on to the next page. I think I copied that child medical evaluation bullet again, but there's also opportunities to enter information for comprehensive clinical assessments or other mental health evaluations, surgical, medical, or dental procedures that require informed consent, psychiatric, psychological, or mental health care treatment that require informed consent, and other non-routine or non-emergency treatment or procedures that are being recommended by a provider. So I'm trying to see if there's other things that I need to say. So county child welfare agencies, I know there was a question in the chat pod earlier about this, are the ones that are required to obtain the authorization from the juvenile's parent, guardian, or custodian. That's not upon the private agencies or the medical providers to obtain that authorization. That is the county's responsibility. Whenever possible, county child welfare agencies should work with parents to address these foreseeable, non-routine care and treatment needs of the child or issues prior to the 7-day hearing. If the parent is not able or willing to authorize the county to provide consent, then the county should ask the court for authority to consent at the time of the 7-day hearing. The second page of the document provides space for the parents to initial certain things, like they have been informed of the recommendation that a certain medication be prescribed as part of the child's treatment plan, that they have been informed of the recommendation that the child is in need of a surgical or medical or dental or mental health treatment, that they have been notified of their child's condition, and that they can contact the provider if they have any questions, and that they have also received a copy of the form itself. They can revoke this consent at any time, and there's a space on the form where you can provide an address where they can send that revocation to, and if they don't revoke, then the authorization expires automatically upon the closure of the case or 1 year from the date that the authorization was signed, whichever comes first. There's options there at the bottom of this box for them to check that they are authorizing the county to provide the consent to the treatment that is discussed above, or that they're refusing to authorize specifically administration of immunizations due to a religious objection. There is a box to provide appointment and follow-up information as appropriate to a parent, the date, the time, the name of the provider, and the location, as well as a place where a parent, guardian, custodian would sign, print their name, and the county child welfare staff would also sign. Copies need to be, the original with the signature needs to be given to the healthcare provider. You need to have a signed copy for your file, a signed copy for the parent, and attach to the court report as well. So, Angie, is there anything that you would like to say about this form or the process of obtaining authorization? Did I cover it?
No, I mean, the only thing I would say is just to emphasize that this doesn't mean, and I think there's been some confusion, but this doesn't mean that the parent has to come to every medical appointment and sign the actual medical provider's form. The parent can authorize it in advance through this form. And the medical providers will be, you know, I've spent some time talking with them. They will be the nice thing about having a standardized form is that they'll be looking for this form or a court order, and so it makes it a little bit easier for them and gives them some certainty that somebody has the authority to consent.
Another thing I'll say is in terms of making sure parents are really fully informed about the treatment itself, and there are options for the parent to check that they've received information that the child needs this treatment or this medication, but I would encourage the child welfare workers to connect the parents with the provider so that the provider can communicate any risks associated with the treatment, any side effects that are maybe anticipated, so that that information can be communicated accurately.
And let me just also point everyone to page 6 of the handout where it has 7B 505.1. If you see the list, there's a list under C that of care and treatment that's covered by this subsection. It's not an exhaustive list, but it would include, so these are things that are not routine and not emergency. These are things where you're going to need either the court order, DSS will need either the court order or parental authorization in order to consent. Prescriptions for psychotropic medications, participation in clinical trials, immunizations when it's known that the parent has a bona fide religious objection to the standard schedule of immunizations, CME not covered by subsection B, which we went over already, surgical, medical, or dental procedures or tests that require informed consent, and then psychiatric, psychological, or mental health care or treatment that requires informed consent. So those are non-routine, non-emergency things where you're going to have to make sure you have authority before you consent.
The other thing that I'll say is that the space out next to these options is to provide a description or information about what the treatment, surgery, or medication is, as much detail as you can provide. This form is not intended for agencies to just check all of these boxes, and you need to be really thoughtful about what the child actually needs, what's being recommended. Oh, and I wanted to let you guys know that we will be sending out the 1812 via change notice by the 1st of March. I'm hoping that we can get it online soon, but we'll let you guys know when it is online.
Thank you, Erin. So we know initially we were going to go into some case scenarios, but we see there's over a lot of questions, and we really want to honor our participants and make sure we answer as many of those as possible. So we're going to switch focus and continue Q&A rather than going in those case scenarios. We'll still leave the case scenarios along with the response to those scenarios in our follow-up document. So someone had a question: can a minor consent to a drug test, or can the DSS worker with custody consent?
So, you know, I think that worker can consent but that's a situation where I think that's technically maybe a medical treatment, and maybe you ask the court. Angie? I mean, we're kind of scratching our heads on that one.
Yeah, and part of it's because I don't know what the purpose of the drug test is, and I think that would be a factor in figuring that out. If it's, you know, there could be some legal consequence of that drug test to the minor. So we'll look at that more for the follow-up document and try to.
So if there's a crossover delinquent case, then the juvenile may have been ordered as part of being an adjudicated delinquent to participate in drug testing, and that doesn't require any further consent. That's by court order if there's a crossover delinquent case. But just in the A&D court, I've not had kids taking drug tests, so, but we'll look at that.
So we will include that in the follow-up document. So a lot of folks had questions about, so what are bona fide circumstances for a parent not consenting to immunization because of religious reasons?
I would direct everyone to the School of Government's blog on the civil side. And if you look back about a year ago, I think it was January of 2015, and we can put this link in the follow-up document. Sarah D. Pasquale did a really excellent blog about immunizations. And it gives so much detail that you'll be an expert on immunizations once you read it.
All right, so we will add that to the follow-up document as well. So another question: if a parent is unavailable or refuses to sign for medications or treatment after the 7-day hearing, can the court order DSS to sign for everything from that point on?
So if the parent refuses to sign, then that's a situation where you're going to have to ask the court to order it. And so I think the answer is yes. But I think that it's not a blanket, you may consent to everything in the hereafter. It's a step by step. As things come up, you've got to go back and ask for permission if the parent won't consent, and it doesn't fall into the category of routine or emergency. Then you've got to go and ask for consent each time, unless unless the parent's consenting.
The one thing I will say is that if it's something that can be anticipated and ideal, I mean, it's likely that if it's not routine or emergency, it's going to be able to be anticipated. Then you can, I think, ask the court for authorization up front. For instance, if you think that the judge is going to try Ritalin first, and if that doesn't work, Adderall, and then have a series that they want to go through, you could ask for consent to all of those things up front and not go back every time the psychiatrist wants to change the medication.
I agree with that. Absolutely.
Thank you. So someone had a question of where is the list that Angie mentioned. So it's on page 6 in your handouts. General Statute 7B 505.1, item C, 1 through 6. There is another question. So does this new law apply to every child in care or just children who came in care after October 1st?
So every child as the medical issue comes up, I think. So that's where we are. Every child when the medical issues come up, if they're not routine or emergency, then it applies.
Okay, and then do both parents need to provide consent, or can one parent give consent?
So if you think about the times as parents you've gone to the doctor who asked for everybody to sign, I think one parent can give consent. I did see a question or a comment in the chat box about the possibility of having a dispute between parents, and that's a real dispute. But legally, if a parent signs a consent, then you've got consent.
I think it would be smart, though, if you know there's a dispute between the parents, to get the court to weigh in on that one.
And I can give an extreme example very quickly. Years ago, I had a child who had a significant brain defect. Mom had found a new surgical technique out in like North Dakota at a hospital that was a risky surgery, but it had the ability to solve the seizure disorder that the child suffered from. The child's life expectancy was not very extensive. I think maybe 10 or 11 years old as it was. But the surgery came with some risks. Dad was afraid to lose the child on the operating room table and refused to consent, and so it came to me to decide whether to consent for whether the surgery could happen or not. So it can get very serious. But we had a hearing where everybody was able to express their opinion, their heartfelt opinions, their fears, and I think that was healthy for both parents to be able to express all of that. Surgery went well. The little girl's still alive, so all that was awesome. I've got a picture of her on my bookcase.
Thank you. That's an excellent example of the power of this law. So thank you, Judge Corpening. So again, we know that we didn't get to all of your questions. We will definitely give answers to as many questions as we possibly can in that follow-up document, as well as point out helpful resources. We'll give you a link to the model court report, the new DSS 1812, those case scenarios, and lots of other things. Just a gentle reminder that you do already have handouts. We'll go back to the beginning slide so you can download the latest version, so you have that new version of the 1812, but there's lots of really good resources in there. Here is the contact information of our presenters. This is also in your handouts at the back, at the end of the PowerPoint. A copy of the PowerPoint slides are included in those handouts.